Okay. There we go. Okay, well, welcome. Today is what is it? April 21st, 2026, and I want to welcome everybody to our April presentation of the Fiduciary Education Forum event. For those of you who are joining us, please keep yourself muted, but if you want to keep your video on, we'd like to see smiley faces. My name is Todd Wohl. I am with Braun International and Premier Estates International Real Estate. Our companies sponsor and work the founders of the Fiduciary Education Forum and fiduciaryforum.com, which is the website that holds our library of presentations and this presentation, both the video and this PowerPoint, this presentation document will be added to the Fiduciary Forum website probably tomorrow. So I want to welcome everybody. For those of you who know us and are part of FEF, welcome back. For those people who are new, this is FEF is our monthly um, presentation that we do on topics that are relevant for professionals and the certain industries that we all tend to be in part of. And our companies have, like I said, founded FEF, but are proud to bring great presenters and very valued educational topics here. And we like this to be conversational. But again, for the people who are joining us, you'll be able to uh, ask any questions to our presenters after the presentation if we're not able to answer your questions. Um, and they are available for your conversation. So I'm a partner at Premier Estates and Braun International. For those of you who know us in the fiduciary world, we've been part of that industry for almost 25 years, and I'm really honored today to have some fantastic presenters and that were willing to take a lot of time to put together this presentation. Richard Huntington, who is a fiduciary as well as a receiver, and has a deep background in real estate and financial estates, is welcomed. Everybody will get a chance to do a quick intro. Eric Becker, an attorney who has worked with Richard for many years, and then jbaker, who is a real estate attorney and also uh, a big supporter of the real estate world through I like to call the receivership forum. His son Ryan Baker is a federal and state court receiver. So I'm really pleased to have everybody aboard. Richard, why don't you just get started and give a quick intro to everybody?
Hey, Todd. Welcome. Thanks for having me. My name is Richard Huntington. I'm a licensed fiduciary and also a certified financial planner. I've been a fiduciary since 2007, and I really enjoy it. I handle a lot of complex, interesting situations and very, family-oriented and family partnerships and complex business structures as well as part of a real estate portfolio. So thanks
Th-
for having me, Todd.
Thank you, Richard. Eric.
Thank you, Todd. I'm Eric Becker. I've been practicing in California since 1989 and exclusively in the area of probate trusts and conservatorships since about 1997. So I've got a lot of experience under my belt in protecting fiduciaries and really got into the practice of working with private professional fiduciaries pretty early on in my career. So I've got a lot of experience in working with licensed private professionals. So I respect you guys, and I think you guys serve a really important purpose in the area of, this area of law.
Thank you, Eric. And then John.
Good afternoon. I'm John Baker, and I'm a real estate attorney, and I've been practicing law for over 30 years, and am uh, have been involved with in fiduciaries and trustees, in many cases, and so I'm happy to be here and looking forward to doing this.
Well, thank you, everybody. So we're going to get started. This is a very interesting topic that we focus on, which is why, as the title says, are you insane to fix up a home? We're kind of focused on residential real estate in this presentation, but there are applications to any kind of commercial as well, um, for any of you who deal with commercial real estate. And the subtitle is why a fiduciary should not remodel and renovate a house prior to sale. So, moving through this, we have a lot of ground to cover today. We may not cover it all, but we'll do our best. The fiduciary needs protection from buyers and beneficiaries. This is a key point we want to make to everybody today. You need to protect yourself from your own clients as well as from the buyers. Um, so, there are many ways to do so, and it is important for you to be prepared and have the right professionals to help you do so. By reducing liability and making the correct choice not to repair or remodel a house. Disclosure is always a very challenged topic. We're going to get into that in a second, but most fiduciaries that I have learned, we work for about 195, 198 fiduciaries throughout the state of California, as well as most of the trust companies in the US. Um, Disclosure is different state to state, but disclosure isn't
Hmm.
necessarily what you don't think you know or what you do know. You need to know what you don't know. And what I mean by that is is thinking about what information you have about the property, and we'll get into that. The fiduciary should engage a property realtor who understands fiduciary duties and liabilities and understands the importance of tangible personal property as well. We'll talk about that in a few minutes. And the fiduciary should effectively communicate with beneficiaries on sale process, including reasons why they are not remodeling or updating a trustor's property. And that's key. These are a number of standard California disclosure documents, but some are applicable to outside of California. And we're not going to get into the actual disclosures themselves at this point in time, but to understand that your professionals should be providing you with these disclosures and what ones you should or should not sign. So, getting into the first question. Should a fiduciary repair a home prior to sale? Richard, why don't you start on this one?
Yeah, thanks, Todd. Todd, I'm not sure if anyone else is seeing the same, but I'm not seeing the slides. Are you sharing the slides right now?
The slides are shared, yes.
Yeah. Oh, you
I'm
guys
seeing
are?
them.
Okay. I don't see them. Interesting.
You're not seeing them?
No, I'm just seeing you. You're on the main screen. Wonder if I'm doing something.
Does anybody else see the?
No, I see you. And
Yeah,
You see the
they,
shared screen?
they're on the screen.
both.
Maybe I'm
Okay.
not.
Okay. So it's okay. So here, I'll read it, just so if you're not seeing it, Richard.
Okay.
Sorry, should a fiduciary repair a home prior to sale?
No. The answer right away, the answer is no. The fiduciary themselves, they're not qualified. You're even if you do have some construction background or even if you're a licensed contractor and a fiduciary, you should not be doing any repairs. It's just you're taking on too much liability. The whole idea of a fiduciary when it comes to real property is that you want to preserve it. And taking on unnecessary risk is not a good way of preserving it. And the reason you're taking on necessary risk is you're making a change, and you're going to be judged on that craftsmanship, whatever you made. So you just don't want to expose the beneficiaries in the trust and yourself, and especially doing the work yourself. It's an absolute no.
So, John, you want to chime in on this point?
Sure. I think the issue here is how can the fiduciary protect himself or herself if something goes wrong? And one way to do it is just to not do it, and the other is to take precautions on that, and we can go into that later.
Understood. Eric.
Yeah, to follow up on what Richard said and what John said, I think, probate code section 16006 says the trustee has a duty to take reasonable steps under the circumstances to take and keep control of and to preserve the trust property. I think a lot of times uh, fiduciaries and the beneficiaries would love for the fiduciaries to increase the value of the trust estate. And I think sometimes the common belief out there is that the trustee should be increasing the value of the trust estate. But the reality is, the duty of the trustee is only to preserve the trust estate. So there may be pressures out there in society for the trustee to add value to the estate, and that's not necessarily true.
Agreed. So our next question, should a fiduciary engage a contractor to remodel and update a home prior to sale? Well, this is the next part of our presentation. Obviously, the fiduciary isn't doing the work themselves. They're going to engage parties to do so. But I think to that point, that fiduciary, of course, is exposing both themselves and the beneficiaries. The beneficiaries may not be aware of liability. They're just aware of how much money they're going to be able to achieve by the sale of the home, if it's fixed up versus if it's sold as is, right? So, John, you want to speak to statutes and some of these exceptions on this page?
Um, well, um, the So the concern is that let's back up for just a second. So the concern is that if you, as the trustee or the fiduciary, fix something up, or one of the beneficiaries says, "Hey, I'm not doing anything. Why don't I go paint it?" Or then the concern is that when the house is sold, that whatever was done will not have been done well, or will have hidden something that the buyer was saying should have been disclosed. And so what we're suggesting is that if you do make any of these changes, then you may create your liability for something that's either breaks after the buyer buys it, or it has hidden something that the buyer says should have been disclosed. So there is a statute of limitations of 4 years for patent deficiencies. The breach of contract is also 4 years. Fraud is 3 years statute of limitations. So it's a long tail to have that risk out there if you go ahead and make these changes.
Correct. Richard, anything you'd like to add here?
Yeah, it's not worth the risk. I put a couple examples down the bottom of the slide. Just like John mentioned, if the beneficiary goes in and paints a wall just to cover up a dirty wall, and it's discovered later that there's mold that they covered up, we've got an issue. And remember too, as a fiduciary, this house sale is a big deal. And once you sell the house and then you've distributed the money to the beneficiaries, and then we get a lawsuit from the buyer on construction defects after the fact of distributing, we're kind of in a world of hurt. It's hard to get monies back. So in my practice, I don't, do anything. I don't want to discover more than I need to discover. I don't want to pull up carpet and see cracks in the foundation and then have a whole nother issue. I'm only doing these exceptions And that's what we have to do. That's what we're mandated to do. The hurricane straps on the water heater, carbon monoxide, and fire alarms, or so.
So, I look, I wholeheartedly agree with what you all say. We had a presentation last week to new fiduciaries and student fiduciaries, or 2 weeks ago, and one party who was on the presentation, there were 70 or 80 people, and this presentation was similar to one we're doing today, but not exactly as in depth. And one fiduciary made a statement, well, I just go in the minute I take over a house, I go and I put in new carpet and I paint the walls and I just want the house to look good. And she didn't think anything of it. And I said to her, well, what happens if you paint the walls and there happens to be mold on the walls? Mold is the number one legal issue for home buyers and sellers in the state of California, in the state of New York, state of Connecticut, and the state of Florida. Mold is number one. And her point was, well, I didn't know there was mold. Well, that's the point. You think you're doing something right by sprucing up the house by painting it. Well, then she said, somebody else chimed in on that presentation and said, well, what if they get a mold test? And I said, well, as a fiduciary, you don't want to have that mold inspection report in hand because now you have to disclose that to buyers, which in effect could affect the sale price. So, as Richard said, you don't know that there's mold. You don't know what the condition of the house is. You're selling it as is. You're making no updates or repairs. And painting the house could actually be one of the simplest things, but could create the most amount of havoc because purely of mold. Okay, going on to the next page. Should a fiduciary allow a real estate broker to remodel and update a home prior to sale? Well, the answer is no. Eric, do you want to start on this one?
Yeah, I think a lot of times, especially in a soft market, a real estate agent may recommend to a fiduciary to, go ahead and put lipstick on a pig. They're going to say the market, the buyers are looking for move-in ready homes right now. They're looking for a house with new carpet, new appliances, new cabinets. So let's go ahead and put a facelift on it, and we're going to go ahead and move this house much quicker. The problem, which Richard just made reference to before, is you pull up the carpeting and you see a crack in the foundation. Well, that's something that all of a sudden is going to need to be disclosed. Richard may not even see that crack before the new carpeting is put down. And next thing you know, next year, there's water coming through that crack in the foundation that Richard had no notice of. And yet it's going to become a problem. So it's one of those things where you're going to have to fight back with the realtor and say, no, we're going to keep the carpeting as it is. You're going to run into situations over time where you may have a trustor who dies in the house, and that body may be laying on that carpeting for 2, 3, 4, 5 weeks before anybody discovers that trustor's body on the carpeting, before the coroner comes in and removes the carpeting. They're going to maybe cut out a piece of the carpeting and there's going to be some bodily fluid staining the concrete. The realtor is going to say, we can't sell the house with that cutout of the carpeting. And you're going to say, yes, this is how the house is going to be sold. So you're going to be, fighting back and basically saying, we're not going to put lipstick on this pig of a property.
So I just
Can I
want to
just
say,
add one thing real
please
quickly?
go ahead, John.
So generally speaking, for all sellers of real estate in California, they have a duty, the seller has a duty to disclose all material information that would affect either the value of the property or what people might want it to be. So that's where we start from, is that if you know something, then you have a fiduciary, not a fiduciary, but you have a duty to disclose that to the buyer. By the same token, the seller has no obligation to go find out things or to look things up. So that's why we say if the fiduciary doesn't know about it, then the fiduciary doesn't have to disclose it. And if once the fiduciary does know about it, then the fiduciary does have an obligation to disclose that to the buyer.
So one person in the chat room says, well, get a mold inspection remediation by professionals if needed. Well, respectfully, if the fiduciary gets a mold inspection report and they find there's mold, the obvious thing is that the family, the beneficiaries, the fiduciary is going to say, well, I guess we got to remediate the mold, which is a whole nother costly procedure. Takes time. But if the fiduciary sells the property and provides the inspection report saying, hey, here's a mold inspection report, there's mold in the home. Obviously, by providing that inspection report, they're doing their duty, but they're now affecting negatively the value of the home. Let the buyer decide what the issues are with the home. Why would you provide an inspection report? If, fiduciaries that are in the Bay Area versus fiduciaries that are in Southern California, in NorCal, when we sell properties in NorCal, it's very common that the agents want to provide inspection reports in advance to buyers in preparation of sale. We do not do that whatsoever. We provide no inspection reports. It's buyer beware. Simply put, the fiduciary shouldn't know. They don't need to know. All they need to know is what they know have been told, and that's it. They don't need to go hunting for that. Another question, separate from our role in selling real estate as fiduciaries, would this be your advice for selling personal real estate? Well, that's an interesting question. John, I'll let you answer that one real quick.
Todd said personal real estate. Did you mean
Correct. So
personal property?
assuming it's the fiduciary has their own house, or the seller
Oh,
has their own
okay.
home. You have your own home, you're selling it.
So again, you have to disclose everything that you know. You don't have an obligation to look underneath the rugs or to open up the drywall to see what's behind it. Um, I, if what I think you can say is, well, this house is 40 years old, so we don't know what's behind the walls or underneath the parquet, but it's 40 years old and stuff happens. And you want, in that sense, you're putting the buyer on uh, on notice that this is 40 years old and there may be stuff that's a problem. And so then it's up to the buyer to investigate.
Mm-hmm.
And it's the buyer's duty to do their own inspections.
No,
That is,
I'm sorry, it's not their duty. They don't have a duty a buyer doesn't have a duty to disclose. They're encouraged to do it, but they don't have a duty to do it. And that's why in the counter offer, I suggest that you make it a duty and you say the buyer will investigate and discuss this.
next question, I'll direct it to you, Richard. Should a fiduciary remove tangible personal property in a home prior to sale? The answer is yes. You want to just chime in about this quickly?
Yeah, absolutely. This is a very sensitive issue. A lot of times when mom and dad die, the trustors pass away, the kids have emotional attachment to some of those things. It could be a spoon collection, the family photos. So you want to handle it very carefully. You got to first look on your EP documents to see if there's a general assignment, someone getting mom's wedding ring, and it'll be identified in there. So that could help alleviate some of the issues because the trustor specifically appointed that item to somebody. And then I usually try to have a family day after that. Bring in the family. If they're not in town, get them photographs and descriptions of the items and let them pick out what they want. Important thing there to remember, though, is if you are distributing to family members, the trust does not pay for shipping and handling unless there's the proper language in the trust. So, you're calling up Johnny on the East Coast and he's supposed to get this desk, let me have your credit card because you're going to have to pay for shipping and handling, then he might not want the desk. So it's important for the trustors to kind of know that, and for the trustees that the beneficiaries are responsible for shipping and handling. And then you're doing an estate sale if appropriate, sell everything off and then donate and trash the rest.
So, just quickly on this topic, I mean, we've when we represent a house, we're doing one right now in the Bay Area, and there's room by room by room full of personal property. We engage companies to do the work of removal, but we actually have extra people by that company or representing the fiduciary's office or even our team that will kind of help weed through things as they leave the house to make sure that there isn't a stock certificate or a can of money sitting behind his dresser. We found that happen once 10, 12 years ago. We had found a little over $43,000 stuffed in a sock drawer in a can that had been there probably for 30 years. Nobody knew about it. And luckily, we went through it and found the money and gave it to the fiduciary. But you don't know what you're throwing away. I could give you many examples of personal property situations where we've ended up getting an estate almost $300,000 for a collection of auto parts where they thought this is just a bunch of junk. They were going to throw it away. So
Yeah.
it is to your point, Richard, it is a very touchy and timely uh, process. There's a question from one of our chat room. How do you respond to all of you? How do you respond to Benny's and others who say that you're just burying your head in the sand and not doing your due diligence in the preparation of the sale of the home? There's a question for you.
Yeah. Well, I think, to me, it seems like a lot of people see those TV shows on flipping a house. They see someone come in and they make up the house and they get more money for it. And that's not a fiduciary's job. And you need to tell the beneficiaries that. I'm telling them that if your mom and dad didn't fix up that house and they kept it the same, then, that's the way the house is. I'm not fixing it up. There's just too much risk, and I'm trying to save you guys from this risk.
So,
So yeah,
right. Yeah, I guess that's the point. What you're trying to do, and you may not be able to do that very well, is because you don't know how to have the conversation. How do I explain to the beneficiaries that the risk you're asking me on your behalf and the estate to take on? Well, that's where you should be talking to professionals like your attorneys, both on the estate and trust side, but also real estate litigation and transaction attorneys, very specialized people to talk to your clients about what risks they have. We'll get into that in a few minutes. Next page, when a fiduciary provides an as-is disclosure when selling a home, does it remove a fiduciary from liability? Eric, do you want to start on this one?
I don't think anything really removes the fiduciary from liability. It definitely helps. I mean, as is means as is, and it does provide some protection. It provides a lot of protection actually, but as is means as is. It means don't do any improvements to the property at all, and as John says, it means that the buyer should do some inspections, has the responsibility of doing inspections, and that, they have the burden of finding any defects that are available to be seen. They're not going to go in and do any forensic testing. They're not going to do any destructive testing, but they should do a complete, thorough inspection to see what is available. And it does provide some protection for the fiduciary. And it may affect the sales price. It may bring the sales price down depending on what defects are discovered. But I do believe it does provide some protection for the fiduciary. There's never going to be a complete protection for the fiduciary, but it does provide some protection.
Can I
Richard, do you
just
want to
yeah,
go
chime in
ahead,
on
John?
that?
yeah.
As,
Go ahead,
as
John.
as is in California is a misnomer because, as I've said, the seller has an obligation to disclose anything that they know. So they can't sell something as is, real estate. They can't sell it as is and not tell tell the buyer that they know that there's a leaky house roof, or that they know that there's mold somewhere, or that something like that. So that's why I think as is a misnomer.
Yeah, and I agree on both those stands. As is you're saying, uh, first of all, you're disclosing everything that you know. You can't hide anything. And so, just like John's saying, a neighbor tells you that the trustor is always saying the roof is leaking, but we're in the middle of summer. Should I tell the new buyer or not tell the new buyer? Well, yeah, you're going to tell the new buyer everything that you know to stay out of trouble. I've got a one right now where the gentleman died on the floor and he was there for a few days. And so we took up huge tiles, just kind of an outline of where he was. And then you have a biohazard team there to clean up everything. And then you get a certification from the biohazard team. And that's it. And I'm selling the property with these tiles missing, just like that example Eric had. And, it's obvious that's where the person passed away. But I'm not doing anything else. I'm not even replacing those tiles. I'm not, there's no fixing it up. It's just as is. And I agree that the best protection that you have is sharing everything you know, disclosing everything you know about the property. Whether you find an invoice from a contractor that did a remodel in the bathroom, 2 years prior. Anything that you hear about, anything you know about, you want to share that. It's the best way to protect yourself.
Well, on that point of disclosure, I guess I'll address it right here. We are very finicky about fiduciary, what they say and what they disclose, how they disclose, what information that they know. The big issue that we find is the fiduciary doesn't remember that they received a text from one of the beneficiaries 9 months ago or 8 months ago that there was a water leak in the ceiling, that there was a roof leak. They got an email a year ago from a property manager and they forget about it. And when the time is to write that disclosure Bible, as I like to say, even though there is an exempt seller disclosure form in the state of California that the fiduciary must sign, they should sign, their agent must give that to them, so because they are exempt, but that doesn't mean that they still don't disclose what they know. And it's going back to the memory question. Because if the buyer buys it and these disclosures weren't made, and then there was a lawsuit and there was a deposition, you're going to have to go through all your records. And at that point, you'll be subpoenaed. And I promise you, because we've been through it, you'll have to remember. So I suggest don't be lazy. Take your time. We spend, in some cases, weeks with fiduciaries putting together the disclosure document, just working on that, because that is the 800-pound piece of information. And I always say to a client, over disclose, because when you do so, the buyer feels comfortable, right? The more comfortable they feel, candidly, even if something popped up after the fact, oh, you know what? They told us all this. We just learned about this after we closed. Oh, okay. It's positioning the sale and, how you feel you want to be perceived with the buyers and the buyer's agents, let alone the attorneys that may represent them. Next page. Let's see. Does a California CAR exempt ESD allow the fiduciary not to disclose known facts regarding the condition at the time of sale? The answer is no. Gentlemen, who wants to start on that one? This is an easy one.
Sure, I will. Yeah, absolutely right, Todd. Yeah, you're not exempt. You've got to disclose what you know. And again, that's your best protection that you have. So the more you disclose everything that you know, and just like your example, Todd, it might save you from a lawsuit because the buyer's comfortable knowing that you shared everything that you know. And again, you're also sharing with them too, is you never occupied this place. This isn't your house. Someone else occupied it. You're just in the office of trustee and you're selling it. And so, there could be things that you don't know about, and especially structural things that you don't know about. So you really want your realtor to be able to let your buyer know that this as is idea is really as is. It's not a lived-in situation where they have inside information on what's going on with the house, and I think that's really effective.
Yeah. Eric or
Yeah, I
John, any?
agree. I agree. I mean, it's you're not going to you're going to disclose as much as you can, and but you're not going to have the duty of figuring out if an addition has been, you know, approved by the county or by the
Correct.
city and things of that nature. So I think, you're going to disclose as much as you can disclose. And as you said, Todd, over disclose. It's better if you have any information at all. If you do find an old construction contractor's invoice, go ahead and have it and save it and produce it to the buyer.
Correct. Okay. Um, Next, does a contractor's insurance cover a fiduciary for liability or construction defects? Yes or no? Um, so I guess, John, do you want to start with this one?
Well, insurance is not my forte, but probably not. Yeah, I guess it would depend on the context of it. Um, for that reason, we haven't really talked about it, but if the trustee has his or her own liability, that may be the best thing to do.
Mhm. Richard, anything to add to this?
Yeah, I mean, I, I look at it from the sense of why should I engage into that idea at all? Because my answer is no, we're not going to fix up the place. So, and ideally, I'm hoping to mitigate the risk enough where I won't be in this situation of having the contractor's insurance have to be used. I haven't done it. I'm not sure the coverage levels of contractor's insurance. But if it's, intensive or, if it covers not only the craftsmanship, but if it covers the damage outside of that, if the contractor has made any kind of indemnity agreements with the fiduciary, how does that come into play? And it's just, I think you're just kind of getting into a situation where you don't want to be involved in.
So
At all.
I guess I'll speak to that because we've been involved in many cases. We do provide remodeling and major renovation services in our construction group, as well as lending for it. But we don't advise it for many reasons that we're speaking about here. But candidly, I think a contractor's insurance company is only as good as the contractor themselves. And really, candidly, and I can speak personally to this point, that $1 million or $2 million general liability policy for construction defect, that insurance company is going to fight back on any kind of defects that the contractor had not repaired, had not done. They're going to fight back. And even if you are indemnified, and this is something to be advised, everybody, if you're going to have a contractor in any form do work, name you as the additional insured by the contractor's insurance company, and they provide that policy to you in advance of doing the work. And that's a laborious step. But by being named as additional insured, you've now put the contractor on notice that you know what you're doing, number one. But number two, you have your entity, your name, or the bennies on there, however, I guess you're engaged. So you are named as additional insurance. Is that a one step better than doing nothing? Absolutely. But if the contractor in 3 years files bankruptcy or can't be found, who do you think they're going after? They're going after the previous owners of the home. And you're in the chain. Richard is in the chain. So that insurance is only worth so much. Now we're taking this example to the nth degree, but we've been involved with properties that we've seen absolutely the worst. And candidly, it is very difficult to remove yourself from liability completely, um, no matter what it is you do. But that is one good step forward to protecting yourself. Um, Next question. Can a buyer of a home after the close of escrow sue a fiduciary for construction defect or property condition issues? Uh, I guess, John, you want to start with this?
Sure. This is what we've been talking about, is that if you close escrow and the buyer finds out later on that there's either a construction defect or that uh, mold wasn't disclosed or that the leaky roof was not disclosed, then the buyer may sue the fiduciary who was in charge of selling it for failure to disclose. It's called constructive fraud, and it happens a lot. I mean, within that realm, it happens a lot. Now, how often uh, it gets given all the number, the houses that are sold, there's not that many people that where the buyer files a lawsuit, but you don't want to be one of those few.
Well, I mean, we're going to talk about a case study. I guess we can speak about it here. We, as a broker and representing a trust, were sued. And the home inspection company was sued, the buyer's agent was sued, the sellers were sued, the fiduciary was sued, everybody was sued because the buyer got an attorney who was very aggressive and did what was called constructive defect testing and found all types of issues behind the walls that the seller had no idea about. And in the end, the insurance companies, which you of course have to claim on your policy because you will be named as a fiduciary if you are sued. So now your insurer has to take the policy; they have to defend it, and that issue becomes a insurers lawyers issue. And the insurer will never go to trial, no matter how right you were in doing everything that you did. The chance of them going to trial and showing that you were correct, they're going to just negotiate and write a check. Would you agree, John?
Yeah.
And to that point, we saw that happen, and eight parties in the example I'm giving you, all those insurers had to pay out, and there was not one liability of by the all the insurers. Everybody said that all the parties involved, inclusive of the sellers, who provided um, very well written disclosures, were liable. But the buyer went through the process. They knew how to play the game, and they ended up with over $800,000. So in the end, no fiduciary wants to get sued because I can tell you a year or two later, you're now digging back through your files and figuring out what happened or what didn't happen. And it not only is it a cost to you, time cost, but it's a monetary cost because it'll affect your insurance. Richard, do you agree? Any things there you want to add?
Yeah, absolutely. Well, and the practicality of it too is this house is already sold. We finished the administration. Everything's been settled, and we've distributed the funds to the beneficiary. So you're talking about a lawsuit after your job's already done, basically, which is frustrating. And like you said, you're taking up time where you're not getting paid. You're taking away your time from other jobs where you can be getting paid. So it's a tough spot to be in. Absolutely.
Yeah. Next question. Should a fiduciary obtain any type of inspection report for the sale of a home? These are the kind of the five biggies: home inspection, pest control, roof condition report, radon, mold test report, both in the air and specific mold on the walls. The answer is no. I don't care what geographic area you are in the state of California, you should not do this. Richard,
Yeah.
tell everybody why you should not do this.
I agree. I agree. Yeah, again, you are not the person that occupied the house. So your level of disclosure is different. We've established that. You're an exempt seller, and part of that exempt seller is this as is statement. So this is a area where you get to use the as is to your benefit in a sense that I'm going to disclose everything that I know about, but I'm not going on a fishing adventure to find more problems. And so by doing these reports, you're actually actively trying to find problems. And that's not your responsibility. You want to make it known to the buyer that if they want to do these reports, go ahead. And maybe they do find something wrong, maybe you have to adjust the price of the house, but it's still as is. You're not responsible to fix it up, even if they find something wrong. It's just a mechanism of them doing their due diligence. So again, you're not actively trying to find issues. You just you share all the issues that you know about.
That's the dividing line. I completely agree with you. John or Eric, any other thoughts?
Nothing on this
Yeah,
slide.
the
Go
one thing
ahead.
that I would add is that to the extent that you can put the buyer on notice that there might be a problem, that works well for you because then the buyer knew about it before they closed. And so, for example, on the roofing, you can say this roof. We believe that this roof is over 30 years old and hasn't been fixed in a long time. We don't know what it's like. This is the summer. We don't know anything about it. Um, mold, mold is, you can say to the buyer, mold is found in many houses and places. We don't know that there is any, but it is a common thing. Um, General things like that, where you put the buyer on notice that there might be an issue, I think works to your favor.
Okay. Who protects a fiduciary when selling a home or any type of real estate? Um, so this is getting into kind of the weeds, part of the weeds of this presentation. For maximum protection, the fiduciary must make prudent man choices to preserve the trust and risk mitigation. The fiduciary can reduce liability by making the correct choice not to repair or remodel the house, and the fiduciary must disclose all material facts. We spoke about this. Um, and speaking about liabilities and specific duties regarding sale, the fiduciary should effectively communicate on the sale process, including the reasons why they are not remodeling or updating the trustor's property. And that's, communicating with your client. And you may want to engage a realtor if you feel they're educated enough and have knowledge enough to explain why that would be beneficial. Or your counsel, who would represent you, you would want to chime in as well. You're doing this for their good as well as for your own. Um, so, selling a home, I mean, this is kind of again going further into the topics that we wanted to add to this. Again, this presentation will be available for you later to review. So there's a lot of information. Um, I wanted to get into, well, John, do you want to get into suing a seller for non-disclosures of home issues?
Sure. Um, So don't lie, I guess is the simple way to put it. And if there's if there's a doubt as to whether you should disclose or not disclose, then you know that you need to disclose it. Even if that doubt shows up in you, then you need to disclose it. Because what you may think is borderline, somebody else may think it was important. Um, um, I don't know what more there is to
Yeah,
say that we haven't already said.
yep, fair enough. And there are certain civil codes that are in the back of this presentation that you can all look into. We've talked about failures to disclose. Um, let's see. Well, I don't want to get into that. Um, Suing for the seller for non-disclosure in the process. This is getting a little bit more into the weeds here. We don't have enough time, but we put this in the presentation for all of you just to be able to review if you want to pay attention to it. It's
And on
here.
this on this slide number 3, it's gone up to $1,000.
Okay, so will you uh, define that, please? Explain that further for our viewers.
So on this business and professions code section, the fine, the penalty has really gone up to $1,000. So any repairs that have been done above the dollar amount of $1,000 now need to be disclosed. It used to be $500. The dollar amount has now gone up to $1,000.
Oh, wow. There you all are,
It's
everybody.
still a pretty low threshold.
That's the point. It's a very low threshold. Just off topic here, real quick, John, for one of our chat room people, would you just explain the difference between patent defect and latent defect?
Um, that goes back a long ways. Now, patent defect, I believe, is um, something that's obvious, and latent is not obvious. Is that what you remember?
Yeah. Open, obvious, and easily discoverable, where latent is basically hidden.
Okay, fair enough. Thank you. On this page, and this is one of many pages. We have an addendum to our purchase agreement, whether we're selling a single family home or a condo for 500,000 or a home for 800,000 or a million. We just sold an apartment complex for $53 million. We require buyers to sign this addendum to the purchase agreement. This is our what we call our proprietary addendum that we use for the sale of any kind of real estate. We have a 100% success rate of buyers signing it. And I can tell you that $53 million apartment sale that we just completed, the attorneys representing that buyer marked it up to the point where there was absolutely nothing left. And we said, well, that's great, but you're not going to buy the property. Either you're signing it or you won't. And the trustees will not sell the property to you otherwise. They sign the agreement without a change. And why I say this is important because your standard listing contract, your standard purchase contract have very minor protections for you as a fiduciary. Our agreement here that we're speaking about, our addendum, be a court, in court or not in court, there are very specific terms in here that's almost and I don't want to say this, it is not 100% an indemnifier, but it is darn close. And so, like I said, we will not sell a property unless the buyer signs this. And this is for what we believe in our company is the best protection for the fiduciary. So the buyer reads it after the fact and they go, wow, I guess I really don't, this is going to be hard for me to sue the fiduciary in the estate. And I'm happy to talk about this later, but this is years of us perfecting in our company. Here are just the appendage regarding the codes and civil codes and trust codes that John and Eric and everybody wanted to have you have in hand so you're familiar with these codes if you need them, just in case. John, anybody want to have any comments about these?
Yeah, I think the on the probate codes. So starting in the 1600s is all of our duties and standards of care. I just threw in there ones that were associated to our topic today. But the main idea is that the court's looking at you as a prudent person. You're a prudent person and you have this stewardship towards the trust assets. And that includes all assets. And you're making them productive, you're preserving them, and you're using reasonable care with your choices. And I think that's the underlining message here for the fiduciary. we're not here to try and capitalize on fixing up a house and making it worth more money. We're here to preserve these trust assets in the name of the beneficiaries, and so that they're getting their monies when we're done, and avoiding risk is the idea.
Yeah, that's
And
right.
and with probate code 16007, to make the trust property productive, it gets a little bit complicated. We're kind of presenting this somewhat simply. Lots of times there's trust litigation and there's parties fighting, and sometimes a property or multiple properties will be in litigation in the trust that you are administering for years. And then the issue is, how does it become productive? Do you keep the tenants in it when the properties become vacant? Do you put new tenants in it? If the roof is leaking, do you get the roof repaired? If there's mold in it, do you abate the mold? It becomes much more gray when you're actually dealing with some of the circumstances. And sometimes the litigation goes on for years and years and years. So, it does become more complicated in real life situations sometimes. And that's where it's important that you have, good counsel, good representation. Um, and I don't want to plug Todd too much, but the language that he has in his counteroffer, when you engage a realtor or a broker, you need to make sure that you have language like that in the contracts that you're working with.
Yeah. Yeah, thank you. I can't, like I said, that was years in the making, and we do not sell a property unless that's signed. And as I said to everybody, it could be a $20,000 piece parcel of land, which we just sold for a fiduciary or a condominium. Doesn't really matter. I don't care what kind of property, retail, industrial, home, you've got, that's what we do because we just don't want to see the parties in some sort of litigation. I think one of the other things I want to add is that we didn't, we just have a couple minutes, and if anybody wants to unmute their mic and ask questions directly, I'll allow you to do that versus the chat. If you'd like to do that, we have a minute. But one thing that we do both, we are a brokerage company and a real estate auction company. Most of you know that. Many times when we're auctioning real estate, all the due diligence is done in advance. There is no in escrow due diligence. It's a very clean process. We don't advocate auctioning over a brokerage sale. They're very different. They have different outcomes from a timeline perspective. But I will say to you, auctioning real estate is another way to quash any concerns or questions regarding the sale process as well as what the buyer knows and that indemnification issue, that indemnifier in our auction purchase agreement, which is very different than a purchase standard state association realtors purchase contract. There we have 100% indemnification language inserted that the buyer is indemnifying the seller, period. So it's very onerous for the buyer, and most buyers don't read that at all. So again, it's a different process of sale, but also very one that may be very much beneficial for everybody. Um, Anybody on here on our presentation, John, Eric, Richard, any closing thoughts you may have that you want to add?
For me, fiduciaries, be careful. Be careful out there. The whole idea of your practice is risk mitigation. So the more you can reduce risk and reduce liability, that's a win. You're doing a good job.
Mhm. Eric, anything in closing?
I'd say 9 times out of 10, you're going to avoid improving a property when you're listing it for sale. Um, and again, fight hard when you're dealing with beneficiaries who say, well, I've got an aunt or an uncle who wants to list the properties for sale. You're going to want to go with a realtor and broker who has your best interest in mind, who has experience with fiduciary sales and who has language in their counter offers like Todd is offering you in this presentation today.
John?
Yeah, I would just say if you find yourself in a situation where there's this tension about whether to do something or not, then you should talk to an attorney or talk to another fiduciary like Richard, and find out what they would do and how to do it. What I like to say with my clients is that I'll tell you where the thin ice is, and how to get around it, and if you fall in, I'll pull you out.
So one thing I'd like to add in closing, you can ask, and candidly, you should ask the beneficiaries to indemnify you for the work that you're asking to be signed on contract to do. Have the beneficiaries indemnify you. Have an attorney like Eric or John type up an indemnification agreement, and they will absolutely happy to do so. And if the bennies are willing to sign it, they're indemnifying you for the work that you're going under contract for, that you're signing. That takes a lot more risk off of your plate. The other side of it is that you could just say to the bennies, now I'm not a lawyer, thankfully, the bennies, you engage the parties, the contractors to do the work. You do the engagement, you handle that, and then I'll sell the house. They're the ones that sign the contract. Now, if there are any issues regarding the work that was done, you'll still be pulled in as a fiduciary post sale for sure. But that's one way to kind of minimize. But I would say to you, get indemnified. And we are doing that right now for a client. It's a $2.4 million home. It's a long story, which I won't get into. We are advancing about $900,000 for a sale price of a home. In about 9 months. It will be about 4.3, 4.4 million. But we were completely indemnified for the work and the advisory and consulting work, and as to the parties involved in this trust. So I can tell you it can be done. So indemnification is probably your best. John, Eric, Richard, you can agree it's your get out of jail free card. Um,
Well,
so
I wouldn't go that far, but it
well,
helps a
I
lot.
figured you were going to say that, John. So I'm covering my bases. But to everybody else, thank you for being on this presentation. As I said, this will be on our fiduciaryforum.com website. And thank you, Richard, Eric, and John for
Yeah.
being involved. We want to thank you. Next month, we will have a presentation toward the end of May. The topic is going to be provided, and for anybody who's interested, we're happy to invite you. And we all thank you for being part of the Fiduciary Education Forum, and gentlemen, for taking time to make this presentation. So thank you, everybody. We want to say sign off and have a good rest of the month of April.
All right.
Yeah.
Thank you, Todd.
Thank you.
See you.
Thank you, everybody. Thank you very much.